Good morning and good afternoon to all joining us today from various parts of the world. Welcome and thank you for joining us for this webinar on this vexed and may I even say fraught topic of the proper law of the arbitration agreement presented by my colleagues Ben Olban, Neeraj Moda, Philippe Kuhn and myself, Stephen Lim. This is a complex topic. Partly this complexity is inherent in the interplay of the multiple laws that can bear on an international arbitration. It is also fair to say English law and other jurisdictions following English law, like Singapore, have needlessly added to the complication and confusion. If we are clear and transparent about what we are trying to achieve with the proper law, which must be to give effect to the parties' agreement to arbitrate, the law need not be as complex and confusing as it is now. This is a matter of relevance, not just for common law jurisdictions, but also for the wider international arbitration community, including our colleagues from the civil law who have kindly joined us today. A typical international arbitration very likely involves two or more parties from different jurisdictions agreeing to arbitrate in yet different neutral jurisdiction, applying yet again a different neutral law to the substance of the dispute. These very often cross common law, civil law boundaries. An example of this is the Kebab G and Kaut case involving parties from Kuwait and Lebanon with arbitration in Paris, English law applying on the merits, and where the English and French courts of appeal disagree on the proper law of the arbitration agreement, the English court finding it is English law and the French court French law. So there is a need for rationalization of this topic, not just within the English common law, but also internationally. We have broadly organized the webinar in two parts. We begin with the discussion on the English and other common law cases, which have unfortunately contributed to the confusion on this topic. In the second part, we will each attempt to provide our views on how the law in this area can be rationalized and our wishful thinking of how the UK Supreme Court should decide the appeals in Anchor and Chubb and possibly Kebab G and Kaut. I'll just mention as well that this webinar is being recorded, so if any of you are not able to watch all the way through with us, you will be able to catch a recording of this later on our Chamber's website. Ben will now introduce some of the concepts and concerns underpinning this topic before we commence discussion of the key and recent common law cases.
Thank you, Stephen. I'm just going to take at the outset a couple of minutes to set the background for the discussions which will follow and address particularly why this topic matters and why we actually care whether the law is in what we've described as being a bit of a muddle. And so doing, I'm going to make three brief points. The first point is that we cannot conceivably start this discussion without mentioning the principle of separability. At its simplest, this provides that an arbitration agreement is taken to be independent of the contract in which it is contained, which I'll call the main contract. But the extent of this independence is very much an issue. It is generally accepted that it means that an agreement to arbitrate will survive an allegation that the main contract is invalid, did not come into existence, or has become ineffective. And the result of that is that an arbitral tribunal, rather than a court, can determine those allegations. But does it mean any more than that? The cases do not speak with one voice on this issue, and we will explore that to a limited extent later today. But what is particularly significant for today's discussion is that it can be accepted that since an arbitration agreement is a separate agreement, it can have a different proper law than the main contract in which it is contained. The second point is, why does it matter what the proper law of an arbitration agreement is? It matters because the law governing the arbitration agreement will determine issues concerning the interpretation of and validity and effect of that arbitration agreement. Just to give a flavour of that by reference to some of the specific issues which arise in the cases we will be considering, the proper law of the arbitration agreement will give the answers to questions such as whether a party that was not originally a signatory to a contract containing an arbitration agreement has become bound by that agreement. It also allows us to ask and answer the question whether preliminary steps in an arbitration agreement, such as negotiation or mediation, are mandatory and have to be completed before arbitration can be commenced. And they also allow us to address the issue of how to deal with what may appear to be a pathological or simply very badly written arbitration agreement. The third and final point is that it's fair to say that arbitration law attracts a fair share of academic interest. It's fair also to say that many key issues in arbitration law have been tolerably resolved over recent time. But this issue of the proper law of an arbitration agreement is today one of the most controversial and unresolved, both academically and in practice. Very different theoretical approaches are championed with different emphases even within the same approach. Different decisions, many of which are irreconcilable, are being reached not just in different places, but in the courts of the very same jurisdiction. Hence the muddle we are going to try to address today. As Stephen said, we are going to start by looking at what the law is as represented in cases in various jurisdictions. And we're going to start with the position in England, and I'm going to hand over to Niraj.
Thanks, Ben. We're going to start with the Court of Appeal case of SulAmérica and Enesa from 2012. The facts of SulAmérica can be stated pretty briefly. In short, a group of Brazilian construction companies were building a hydroelectric dam in Brazil. There was an incident in 2011 and the companies claimed on their insurance. The insurance policies provided for Brazilian law as the exclusive governing law of the contract and for Brazilian courts to have exclusive jurisdiction over disputes, but there was also a clause providing for arbitration in London. Now, the companies argued that the arbitration agreement was governed by Brazilian law. They said that because the insurance policies were contracts of adhesion, under Brazilian law, arbitration could only be valid at their behest. So they began court proceedings in Brazil. The insurers, however, claimed that the arbitration agreement was governed by English law and that court proceedings in Brazil were in breach of that arbitration agreement. So the insurers sought an anti-suit injunction in the High Court in England. At the first instance before Mr. Justice Cook, the insurers were successful. The judge noted that the insurance policies were in Portuguese. They provided for the exclusive jurisdiction of the Brazilian courts. All of the actors in the dispute were Brazilian, and the risks that were insured were also in Brazil. But the judge found that there was both no express choice of law for the arbitration agreement and no implied choice of law either. He then went on to find, applying the conflict of laws rules, that the law with which the arbitration agreement had its closest and most real connection was English law, principally because the parties had chosen a London seat for their arbitration. The companies then appealed. In the Court of Appeal, the case came up before Lord Neuberger, Lord Justice Morbick, and Lady Justice Hallett. The Court of Appeal decided that there was a three-stage test for determining the law of an arbitration agreement. First, if there's an express choice of law, then that is determinative, and that's not really controversial. Secondly, where the parties have not expressly specified the law of the arbitration agreement, the court will consider whether the parties have impliedly chosen a law. And thirdly, where it's not possible to establish the law of the arbitration agreement by implication, it's then necessary to consider what would be the law which has the closest and most real connection with the arbitration agreement. Lord Justice Morbick, in the leading judgment, stated that the starting point was that in the absence of any indication to the contrary, the parties intended their whole relationship to be governed by the same system of law. He later stated that usually the implied choice of law for the arbitration agreement will be the law of the substantive contract, unless there are factors present which point to a different conclusion. And these may include the terms of the arbitration agreement itself, or in his words, the consequences for its effectiveness of choosing the proper law of the substantive contract. So where there is no express choice, From Sula America, we get the test that there is a presumption that the main law of the contract applies by implication, and the seat mentioned in the arbitration agreement, or whether a particular choice of law is ineffective, may lead to that presumption being rebutted. These observations all demonstrate that the court had in mind choosing a law which would give effect to arbitration. We know that choosing Brazilian law would have scuppered any prospects of arbitration, according to the insured, the construction companies in their case. Lord Newburgh, in his judgment, considered that the prior authority on determining the law of an arbitration agreement was not entirely consistent, and perhaps that was something of an understatement. It's still not entirely consistent. Lord Newburgh then went on to comment that once it is accepted that the issue is a matter of contractual interpretation, it may be inevitable that the answer must depend on all the terms of the particular contract when read in light of the surrounding circumstances and commercial common sense. Without giving too much away of my own approach to this, that is an interesting comment, and we will come back to it later. The real problems with the Sula America test come with stages 2 and 3. It was accepted by Lord Justice Moore-Bick that these two stages blur into each other. In Sula America, unfortunately, there was no proper analysis of why or how you would imply a term into the arbitration agreement. The court went pretty quickly on from stage 2 to stage 3 of the test, and even then there was no real guidance on whether there's a hierarchy of factors when considering which law has the closest and most real connection with the arbitration agreement. The Court of Appeal clearly had an eye on the fact that Brazilian law, as the governing law of the arbitration agreement, would have invalidated it, but they did not decide the case on that basis. So the outcome from Sula America was, respectfully, a bit of a mess, even if it was the right decision on the facts. I'll now hand over to Ben, who will pick up on the controversial case of Kebabji.
Yes, I'm going to address the next major case in our list of cases for today, which is Kebabji and Kaut Food Group. The proper law issue that arose in this case arose in the context of a dispute as to whether the respondent in the arbitration was a party to the arbitration agreement in a main contract. The contract was originally concluded between the claimant and a third party that subsequently came to be a subsidiary of the respondent. The claimant contended that the respondent had by word and deed succeeded to the third party's rights and obligations, including becoming a party to the arbitration agreement. Now, in this case, the main agreement contained an express provision or provisions that it was governed by English law. The arbitration clause did not contain its own express choice of law, but it did provide for ICC arbitration in Paris. The Paris-seated tribunal issued an award in which it concluded that the law governing the arbitration clause was French law, and that the respondent was a party to the arbitration agreement. The successful claimant then tried to enforce the award in England. The respondent sought to resist enforcement on the basis that the tribunal had not applied the law selected by the parties. It said that the arbitration clause was governed by English law. At the same time, the unsuccessful respondent sought to have the award set aside in Paris on essentially the same basis. That is, that the arbitration clause was governed by English law, and that as a matter of that law, it was not a party to the arbitration agreement. Now, the matter came before the Court of Appeal in England in January of this year. Ultimately, the court denied enforcement on grounds that the respondent ought not to have been found to be a party to the arbitration agreement. So far as the issue of the proper law is concerned, there are really five main points. First, it was common ground that the question whether the respondent had become a party to the arbitration agreement fell to be determined in accordance with the proper law of the arbitration agreement. Secondly, it was acknowledged that the proper law of the agreement could be the result of an express or an implied choice. And then the Court of Appeal held that a broadly worded governing law clause in the main contract, along with other provisions in the main contract, as well as a provision in the arbitration clause itself that directed the arbitrators to apply all the provisions in the agreement, amounted to an express choice of law for the purposes of the arbitration agreement. The court then went on to say that that express choice was not negatived by the express choice of Paris as the seat of the arbitration. Finally, the Court of Appeal acknowledged that if it were true in this case that the governing law provisions in the main contract provided the governing law for the arbitration agreement as well, then that could conceivably be the case in every contract that contained an express choice of law clause. But the Court of Appeal resisted that as being a necessary conclusion on the basis of the particular wording of the relevant provisions in the contract before the court. So, in one sense, kebab is not all that significant. It's not disputed that if there is an express choice of law governing an arbitration agreement, that really is the end of the matter. Where this case does contribute to the debate is in fleshing out what sort of express wording in a main contract will be regarded as sufficient to amount to an express choice of law for the purposes of the arbitration agreement as well. Questions of construction of contracts are invariably and notoriously case-specific, as we all know, and reasonable minds can readily come to different conclusions. Many commentators have suggested that the approach of the court in kebab suggests a more permissive approach to finding an express choice of law for the arbitration agreement by reference to the express provisions of the main contract. Now, I think that's arguable, but in any event, the decision has been both roundly applauded and roundly criticised on this basis. Moving on quickly, the set-aside proceedings in France, to which I've already referred, moved at a slightly slower pace. In a decision published on the 26th of June, only last week, the Paris Court of Appeal rejected the application to set aside and found that the respondent was in fact a party to the arbitration agreement. Contrary to the conclusion of the English court, the French court did so on the basis that as a matter of a delocalised or non-national international arbitration law, which the French courts apply, arbitration agreements are, in the absence of express provisions, presumptively to be governed by the law of the seat. Now, the justification in this case was that this choice of the seat represents the will of the parties as to the proper law of an arbitration agreement. The result now is that the English Court of Appeal is refusing to recognise and enforce a French award on grounds that the French court has rejected. In some ways, this is reminiscent of the notorious Dalla case, but it's probably not as significant as that one. Although there is a theoretical conflict, or a conflict in theoretical approaches, ultimately the difference in this case appears to lie on appears to resolve itself into a question of construction of the express provisions of the main contract. Now, as Stephen alluded to at the start, this is not necessarily the end of the story. An application for permission to appeal to the United Kingdom Supreme Court was filed in February of this year. As we understand it, that application remains outstanding. It may have been held over to await the Paris Court of Appeal's decision, or the English Court of Appeal's decision in Enka and Chubb. We don't know. And it is conceivable that an appeal in kebab will be consolidated with an appeal in the Enka and Chubb case. Now, I will pass on to Philip to address that case, Enka and Chubb.
Thank you, Ben. And I mean, another possibility is that Enka is heard first and kebab could be heard and then both judgments are handed down together. So there are other permutations. I will deal quite briefly with Enker because in part 2, I will try to defend the underlying reasoning, defending the law of the seat by implication approach. So at this stage, I'll just sketch the facts and the key conclusions and then develop that more fully in the second half. Enker was a Turkish construction and engineering company. It had very substantial Russian operations, and this particular dispute concerns Enker's role in the construction of the Berekovskaya power plant for a company called Unipro. Enker was engaged as a subcontractor to provide works relating to the boiler and auxiliary equipment under a contract concluded back in 2012. One point that I'll come back to if time permitting is that there wasn't the clearest express choice of Russian law for that substantive contract, and that does feature later on in the reasoning of Lord Justice Popperwell. Chubb is the subrogated insurer of Unipro, and we're dealing here with the Russian arm of the wider insurance group. Chubb paid out after a fire at the power plant in 2016 and then proceeded to file a claim against Enker in the Russian courts. And in very simple terms, it alleged that the fire caused at the power plant was due to Enker's defective work. In parallel proceedings, Enker then applied for an anti-suit injunction in the English Commercial Court to restrain the Russian proceedings brought by Chubb. And importantly, Enker's contract with Unipro contained a London-seated arbitration clause. So there were essentially two questions for the Court of Appeal, and it's quite significant, particularly in the context of this webinar, to focus briefly on both, because the reasoning on the first question, which was about whether the forum non-convenience principles apply to the question of enforcement of London-seated arbitration agreements or clauses by means of an anti-suit injunction, apply or not. And it was only the second question, the second question was what the proper law of the arbitration agreement was. And in a unanimous judgment given by Lord Justice Popperwell, with whom the other two members of the Court of Appeal agreed, the Court of Appeal disagreed with Mr. Justice Andrew Breaker at first instance on both questions. As to the first question, the simple conclusion that the Court of Appeal drew was that when you've got an English-seated arbitration, it is necessarily appropriate, or it is the appropriate court to consider anti-suit injunctions, and forum non-convenience considerations don't arise. There are still discretionary factors that may point against granting that relief, but it is squarely a question for the English court or the appropriate court by reference to the seat to decide. And that then leads to the second question, and that's the main interest here. And going back to the Sulamerica approach that Neeraj explained a moment ago, the Court of Appeal in Enker modified this quite substantially. While it preserved the three-stage structure, it said that the correct or preferable approach, and the approach that English law was to take from now on, was to apply a strong presumption in favor of the law of the seat, absent an express choice for the proper law of the arbitration agreement. And commenting also on the Kebabji decision, as Ben has just explained, and in a sense is confirmed, at least at this stage in Enker, that decision was seen as a decision on its facts, dealing with stage one of Sulamerica, i.e. what will amount to an express choice of the proper law of the arbitration agreement. And as far as I can tell, there was only a paragraph or two on Kebabji. So in Enker, the Court of Appeal was quite focused on limiting that reasoning to its own facts. The important point, or a number of important points, are the strong link between the reasoning on the question of anti-suit injunctive relief and the proper law. As I'll explain later on, Lord Justice Popperwell saw real traction in the concept of contracting into an arbitration package, and he really emphasized the supervisory role of both the law and the courts of the seat. Another point, which in a sense one already saw foreshadowed in Sul America, is that there isn't huge scope anymore on this approach taken by the Court of Appeal in Enka for stage 3 of the analysis, focusing on the closest and most real connection. And I would suggest that if this particular approach is upheld, we may move to what is effectively a 2-stage approach where you have a rebuttable presumption in favor of the law of the seat and no great scope for stage 3 of the Sul America analysis in substance. And in a sense, what's interesting about this decision is that it wasn't strictly necessary, at least on one view, for the Court of Appeal to deal so fully with the proper law question, because, as I said a moment ago, there wasn't a particularly clear choice of Russian law. And towards the end of the judgment, and this may be of interest, at paragraph 107, Lord Justice Popplewell concludes that there wasn't an express general choice of Russian law for the substantive contract. Instead, he said that the choice of Russian law, expressly at least, was confined to questions of regulatory compliance with particular questions or provisions of Russian law. And also at the end of the judgment, and this is my final point, there's a treatment also of the judge's alternative ground for refusing the anti-suit injunction, and he deals there with delay by Enka, participation in the Russian proceedings, and Enka's failure to commence arbitration. So the Court of Appeal really covered all the bases, and I think it's important to see the different issues that are actually floating around in the case, not least because the Supreme Court will probably approach it in the round in the same way. And now over to Stephen for a commentary on the Singapore decisions.
Thank you very much, Philippe. I will deal with Singapore quite quickly. I won't go into the facts of the case. So my intention is really to bring out where Singapore agrees with and then diverges from the English law position. So Sul America was first considered in Singapore in First Link Investment Corporation, which is a registrar's decision of the High Court in 2014. The registrar adopted the 3-stage test in Sul America, but departed from Sul America on what was the presumptive implied law. In that case, the registrar found the law of the seat would be the presumptive implied law. To some extent, we have a bit of a reverse situation in Singapore where Sul America was not copied at first, and the registrar went for the law of the seat. And then I'll tell you later that this is reversed in the High Court. Amongst the court's reasoning was that the businessman must intend an award to be enforceable, and so would therefore focus on the law of the seat and whether that law recognizes and enforces the arbitration agreement. In my view, this not only imputed too much to businessmen, but was also misguided. First, awards are likely to be enforced in jurisdictions outside the seat. So the law of the seat, while important, is not the only law of relevance. And second, and perhaps more importantly, this ignores that the New York Convention and Model Law, which applies in Singapore, provides for presumptive validity of the arbitration agreement, subject only to internationally accepted grounds of invalidity. And this is in Article 2 and Article 8, Article 2 of the New York Convention and Article 8 of the Model Law. In other words, a New York Convention and Model Law seat is required to give effect to arbitration agreements, subject only to limited exceptions, along with other New York Convention and Model Law jurisdictions. Therefore, applied correctly, the seat court is required to accord maximum validity to the arbitration agreement. Also, in Article 5.1a of the New York Convention, and this is replicated in Articles 34.2a1 and Article 36.1a1 of the Model Law, which, as I said, applies in Singapore, recognizes the parties' express and implied choices of the proper law of the arbitration agreement. Therefore, the Singapore court is required to recognize and consider the validity of the arbitration agreement according to the law expressly or impliedly agreed by the parties. Singapore law is the law of the sea. It only applies in the absence of an indication of an express or implied choice. So I think there were some flaws in the reasoning of the registrar when he rejected the presumption of the law of the contract in Sulamerica. There was therefore some uncertainty in Singapore as to whether First Link represented the law in Singapore, or Sulamerica represented the law in Singapore. This lasted for about 2 years. And in 2016, First Link was effectively overruled by decision of the judge of the High Court of Singapore in the case of BCY and BCZ. And the High Court in BCY and BCZ adopted the Sulamerica test and agreed that there is a presumption that the implied law of the arbitration agreement contained in the contract was the law of the substantive contract. The court held parties are assumed to have assumed the whole of their relationship to be governed by the same system of law, and the choice of a seat different from the law of the substantive contract would not in itself be sufficient to displace this. That the law of the substantive contract would only be displaced if this would negate the arbitration agreement despite the parties' clear intention to arbitrate. I pause there to note that the court's emphasis here was whether the presumptive law invalidated or negated the party's intention to arbitrate. And I'll come back to that later in my comments in the second part. What the court said in agreeing with Sulamerica as well, that in a freestanding arbitration agreement, the law of the seat was likely to be the proper law of the arbitration agreement. And the latest update to this is that at the end of last year, just before Kebabji and Court was decided by the English Court of Appeal, the Court of Appeal in Singapore approved the decision in BCY and BCZ. This was perhaps no surprise, as the same judge, having then been promoted to the Court of Appeal, wrote both judgments. So the law in Singapore, as it stands, is the Sulamerica approach, as confirmed by the Court of Appeal. One final comment I'll make before leaving this, the Singapore law at this point, is that the High Court in the BNA and BNB case applied the Sulamerica and BCY three-stage test in finding that the law of the substantive contract was displaced in that case by the law of the seat because it would have invalidated the arbitration agreement. And the court found that the law of the seat was the implied choice. And so in that sense, Singapore does take a slightly different position from Sulamerica, in that Sulamerica, when the Court of Appeal found that the law of the substantive contract was displaced, it then went to the closest and most real connection test, whereas in Singapore, as I think Philippe has mentioned in Anchor and Chubb, it is dealt with at the implied law stage at stage 2. Let me then hand this over to Niraj, who will sum up where we are.
Thanks, Stephen. So what are the options open to the Supreme Court? It's fair to say that this is the first time that the question of how to determine the law of an arbitration agreement has cropped up in the highest court. The issue was briefly touched on by the Supreme Court in Dalla, but of course Dalla was looking at it from a different perspective, from the perspective of the validity of an award as opposed to deciding how to determine the law of an arbitration agreement. There are also some dicta from Lord Mustill in the 1993 House of Lords case of Channel Tunnel and Balfour Beatty, which referred to in Enger as well. In that case, Lord Mustill suggested that the law governing the arbitration agreement would only differ from the law of the substantive contract in exceptional circumstances, and the law of the arbitration agreement was more likely to differ from the law of the seat, which I think it's fair to say these comments are obiter do not reflect the recent trend of cases. So our view is that there's nothing limiting the Supreme Court from deciding this issue completely afresh. We say that these are probably the following options that are open to the Supreme Court. There are 4 of them. First, the Supreme Court could maintain the status quo. It could approve the test in Sulamerica and hold that the 3-stage test applies with a rebuttable presumption in favour of the law of the main contract as the law of the arbitration agreement. This would be a pretty safe course for the Supreme Court, since it would not involve any real change in the law, but arguably it would be a missed opportunity to bring coherence and clarity to the question. Secondly, the Supreme Court could decide to switch the presumption in favour of the law of the seat. So this is effectively the case or the approach taken by Lord Justice Popplewell in Enker. The Supreme Court could decide that in the absence of an express choice, rather than the uncertain distinction between stages 2 and 3 of the Sul-America test, there's a presumption that the parties have selected the law of the seat as the law of the arbitration agreement, and only where there are powerful countervailing factors going the other way, and those words are taken from Enker, would that presumption be displaced. Thirdly, the Supreme Court could go back to basics and emphasize the processes of interpretation and implication. This is a contract law 101 approach, maybe. It would involve placing the test squarely within the common law orthodoxy on interpretation and implication of terms in contracts. That would be a little bit controversial. Perhaps it would come up against the principle or the debate between how far an arbitration agreement is separate or severable from the main contract. But again, the Supreme Court could approach this question without rocking the boat too much. And fourthly, and much more radically, the Supreme Court could choose an approach which gives effect to the validation principle. Some very eminent practitioners are in favour of the recognition in English and common law of the validation principle. So that would involve choosing the law of the arbitration agreement, which has the purpose of upholding the arbitration agreement and mirroring principles of validity that Stephen has discussed a little bit earlier. So the difference between this and the third option would be that the Supreme Court would be forging a completely different path and emphasizing the supranational character and effect of the New York Convention. So ultimately, the Supreme Court could analyze this in a number of different ways. Handing over to you now, Stephen, how would you argue this before the Supreme Court? Which way do you think they will go?
Well, as foreshadowed in my comments on the Singapore law position, I think it is time for the English common law, including Singapore, to reassess the Sul-America test and its confusing progeny and realign with the New York Convention. First, the Sul-America test does not conform with the New York Convention. The third stage of the Sul-America test looks at the law of the closest and most real connection. The New York Convention is a similar, sometimes people say it's a 2-stage or 3-stage test. It looks first to the express or implied law, which is either seen as the first or second stage. And in the absence of any indication, the convention then provides for the law of the seat to apply. So in the third stage, it is the law of the seat that applies, not the law of the closest and most real connection. Now, this may not in itself make much practical difference in that most cases, the choice of law, if not expressed, is likely to be resolved by an implied law at the second stage. And I agree with Philippe, that is the way the law should go. And in any event, the law of the closest and most real connection is quite often also the law of the seat, and that was recognized by Lord Justice Morbick in Sul-America and also other judges dealing with this issue. However, as the case of Kebabji and Coates shows, the English court's reliance on English contract precedent for determination of the proper law of the arbitration agreement can potentially lead to greater divergence. In that case, the Court of Appeal questioned, but did not decide the issue because ultimately it was decided on the basis that there was an express choice of English law, whether the requirement of business efficacy in the English Supreme Court case of Marks and Spencer and B&B Paribas could be satisfied by the Sul-America test or the New York Convention, provided a fallback default choice of law of either the law of the country with the closest connection under the Sul-America test or where the award was made under the New York Convention. In other words, was there a necessity for an implied choice if there was a fallback default choice? In my view, going down that route would be a significant departure then from the requirements of the New York Convention. And English contract law principles with implied terms should not be applied to the determination of the proper law if English law is going to be consistent with the New York Convention on this point. Moving on to how I think the English authority should move towards would be that English authority has vacillated between giving primacy to the substantive law of the contract and the law of the sea. You've seen that in the brief description we've had of the cases. Instead of laying down a presumptive implied law, which is then rebutted if it invalidates the arbitration agreement, it makes more sense, and in my view, it is more transparent, to apply the validation principle. And in any event, this is required, in my view, and in the view of many eminent arbitration commentators and practitioners, as has been mentioned. It is mandated under Articles 2 and 51A of the New York Convention. The validation principle gives effect to the parties' commercial intention to agree an effective and workable international dispute resolution mechanism, and it provides that if an international arbitration agreement is substantively valid under any of the laws that may be potentially applicable to it, then its validity will be upheld, even if it is not valid under any of the other potentially applicable laws. And as I mentioned, this is mandated first under Article 2 of the New York Convention, which is reflected in Article 8 of the model law and therefore also applies in model law countries, and is also found in Section 9(4) of the English Arbitration Act. And this requires that the court give presumptive validity to arbitration agreements subject only to defined generally applicable exceptions of contract law, that it is null, void, inoperative, or incapable of being performed, without reference to national rules which subject international arbitration agreements to special, discriminatory, or idiosyncratic burdens or treatment. And further, as I've mentioned as well, Article 51A of the New York Convention, which is reflected in the model law and also in Section 1032B of the English Arbitration Act, provides a choice of proper law rule, which, as I mentioned, looks to the law to which the parties have subjected it, whether it's an express or implied choice, or failing indication thereof under the law of the country where the award is made, therefore the law of the sea. While there is some debate about whether this choice of law rule in Article 51A also applies in Article 2, I think there's a strong case that for consistency in the recognition of arbitration agreements and awards, the same choice of law rules in Article 51A should also be applied in Article 2 when considering the validity of arbitration agreements. Therefore, Article 2 requires states to recognize and give effect to parties' agreements in the proper law of the arbitration agreement, whether express or implied, and the implied choice would be the law that gives effect to the parties' agreement to arbitrate. Now, while I advocate the adoption of the validation principle, I recognize that it is quite unlikely to find favor with the Supreme Court. The validation principle does not get much mention in the English common law line of cases. And I detect there's either indifference or even antipathy towards it. In my view, this may be because it is not fully understood. In the BNA and BNB case that I've mentioned, that decided in favor of the Sul-America test at the Court of Appeal, in the first instance there, the High Court had to expressly consider and then rejected the validation principle. And it was on these grounds that it was impermissibly instrumental, that it could be inconsistent with the party's intentions. It was unnecessary because Singapore already endorsed the principle in the Latin maxim, which the judge called the ut res magis principle. In other words, that words are to be understood in a manner that the subject matter be preserved rather than destroyed. And also that it could create problems at the enforcement stage because Article 51A of the New York Convention contains choice of law provisions starting with the party's intentions, whereas in the judge's view, the validation principle seeks to validate an arbitration agreement without necessary regard to the party's choice of law. Before I go on and give my view on these criticism of the validation principle, I just note that even though the High Court rejected the validation principle, it effectively applied a validation approach. In that case, reading the words arbitration in Shanghai as designating venue only and not the seat, in order to find that the seat was actually Singapore and not Shanghai, therefore allowing the law of Singapore as the seat to displace the law of the substantive contract, which was PRC law in that case. So even though the court didn't agree with the validation principle, it effectively took an approach that tried to validate the arbitration agreement. Coming back to my responses to the court's rejection of the validation principle, in my view, the validation principle is not inconsistent with the party's intention. the aim of the validation principle is in effect to give effect to the parties' agreement to arbitrate. And it is instrumental only in giving effect to the parties' agreement, which, in my view, is what English contract law also strives to do. And more importantly, there is no conflict between the validation principle and Article 5.1a of the New York Convention or in Article 2, because the validation principle, as I explained, is actually derived from Articles 5.1a and Article 2. And if, as I've suggested, the same choice of law principle should apply at Article 2 at the stage of determining the validity of an arbitration agreement, and in Article 5.1a, when determining whether an award should be refused enforcement, then there should be no conflict at all between the validation principle and Article 5.1a. Let me then pass this on then to Philippe for his views.
Thank you, Stephen. I will develop the analysis in Enker and Chubb, but with a slight difference in emphasis, I think. My preferred approach normatively would be a two-stage test. At stage one, which is uncontentious, a search for the express choice. And I would say that Kababji and Kaut is probably, for me, at the outer limit of that, and others will have looked at the judgment very closely as well, but it wasn't the clearest express choice there. There was emphasis on the wording of disagreement and one other auxiliary cross-reference between the arbitration clause and the general applicable law clause. But for me, that's probably at the outer limit. And if you're not in that express choice territory, I would propose quite consistently with Enker and Chubb a rebuttable presumption in favor of the law of the seat also being the proper law of the arbitration agreement, at least when dealing with a London or English seated arbitration. So looking at it from the English law perspective. And the route by which I arrive at that result would probably be as a general imputed intention, which is particularly powerful where the law of the seat has been chosen expressly or clearly. And one of the criticisms of the approach I'm defending, which I will try to address a little bit, is what do you do where the seat itself is not clearly chosen? And in my view, there are two main arguments in favor of this law of the seat presumption. And I take them really in reverse order from how Lord Justice Popplewell dealt with it in Enker. He started with separability and then spoke about the arbitration package concept. For me, it's really the arbitration package concept that is critical. And in my view, when you choose a London or English seated arbitration, and the same is true of many other possible seats, be it Paris, Hong Kong, Singapore, Dubai, and so on, is that you're contracting into a particular system. And that may be for reasons of neutrality, certainty, and quite importantly, in my view, with an eye on what sort of powers the courts and the law of the seat would have. And in England, that's particularly relevant to questions of anti-suit injunctive relief, which is, as I said, quite an important question in Enker itself, and also as to issues challenging awards or at the preliminary stage, the jurisdiction of an arbitrator to proceed with hearing a dispute. And those sorts of issues we see in the Kababji case. So the recent 2020 cases in England really show the spectrum of where these issues are relevant. And in Enker, interestingly, there's some discussion of whether choosing England as a seat, and as I said, the same principle would apply to other seats, is almost tantamount to an exclusive jurisdiction agreement in other contexts. And really the short point here is, if the parties have chosen the English court's machinery as a presumption, why would they not also want English law to govern questions such as validity and enforceability? The second point or argument in favor, as I said, is the principle of separability. And this is really now well established in English law. It's not only embodied in Section 7 of the Arbitration Act, but also has been very clearly and strongly endorsed in the well-known Fiona Trust case. There are stronger counter-arguments, I think, on that point, and in both Sul America in this jurisdiction and BCY and BCZ in Singapore, the point is made that while it's correct to say that the substantive contract and the arbitration agreement are separable, that doesn't mean that they necessarily have to be insulated or hermetically sealed. And I accept that there's some force in that reasoning, but if one takes the flip side, which would be to say there's great significance in the substantive law of the contract, and perhaps that should form the basis of a general presumption, I have some concerns about that sort of reverse reasoning, taking again cases like Sul America dealing with Brazilian law, or perhaps a better example, ENCA itself, with the questions of between a Turkish and a Russian party in the context of an international project, whether Russian law really was seen as desirable by both parties as governing the dispute resolution machinery. And I think particularly in those sorts of contracts, the neutrality considerations are a fortiori or even stronger. And for me, the third point in favor of this clear presumption in favor of the law of the seat is that it enhances legal certainty. But it is important, and I accept, that express choices should be given effect and that it is truly a rebuttable presumption. It shouldn't be applied in an overly rigid way. And one case example in the English context, which I would personally endorse, is the case of Arsenovia against Cruise City Mauritius Holdings, which was a 2012 High Court or Commercial Court decision. And in that case, the law of the seat, London, or English law, was rebutted on the basis that the substantive contract, a shareholders' agreement, was governed by Indian law, but there had also been an express exclusion of certain provisions of the Indian Arbitration and Conciliation Act. And that was, in my view, quite a sensible way of finding an exception to this presumption in favor of the law of the seat. And I'm mindful of the time, so I will just deal really with what I think is the best objection to this approach, which is that, as was accepted in ENCA, you can't really have a floating proper law of the arbitration agreement, which means you might have circularity. You might be in a position where the law of the seat is itself not very clear, and if you then have a presumption which relies on the existence or the clear choice of a law of the seat, you might be proving one thing to prove another, and there would be difficult questions about which law you then apply to identify the seat, where that is also relevant to the proper law question. In practice, there are mechanisms in most of the institutional rules for identifying the law of the seat, even where that isn't done expressly, and there is also English case law guidance on the issue. And as perhaps a final concession, I do accept that Stephen's approach, or a validation-based approach, is more in tune with the New York Convention. The English approach, and the approach that I've suggested, focuses much more on the dynamics of the English jurisdiction and arbitration forum. And with that, I hand over to Neeraj.
Thanks, Philippe. I'll be brief because we are short on time. We've had a good discussion, I think, so far. For me, as I've already indicated when I was dealing with the case of Sul America, I would focus on contractual interpretation and implication. And I don't think that there are real concerns with that approach. It's an approach that's familiar to the court and the Supreme Court, having dealt with cases on contractual interpretation over the last few years. And it's also familiar to common law practitioners. After all, an arbitration agreement is a contract. Why not interpret it and imply terms as necessary, as provided for in the common law, as you would with any other contract? So for me, it would be open to the Supreme Court to set down these principles, although it may not be argued in this way. Certainly if Kababji is appealed up to the Supreme Court, these issues or these arguments may well be on the court's radar. I would have stage one, uncontroversially, express choice is determinative. Stage two, if there is no express choice, there is a process of implication, whilst that is not terribly controversial, what is controversial is how long you spend on stage 2. And as I mentioned earlier, in Sud America, the court moved very quickly on from stage 2 to stage 3 and did not deal with or discuss on what basis might you imply a term into the arbitration agreement to give it effect. And I think that's unfortunate. And there have been cases, there's a Marks and Spencer case that Stephen mentioned at the Supreme Court. And I think that gives you good guidance on why or how would you imply a term into the arbitration agreement. We know that business common sense and considerations of commerciality are as important as they ever were. In Marks and Spencer, Lord Newburgh emphasised that a term will be implied into a contract, a common law, only where it satisfies a test of business necessity or it is so obvious that it goes without saying. In my view, the process of implication can be used to give business efficacy to an arbitration agreement. If implying the law of the main contract upholds the intention to arbitrate, then that's what the parties intended. If instead the law of the seat will validate the arbitration agreement, then that must be the proper law. I can see how this may be seen as a little bit reductive, but actually, if one considers that when parties enter into an arbitration agreement, they are contracting for a particular form of dispute resolution that will be valid and will result in an enforceable award. So if one accepts that that is the intention of contracting parties, then why could you not, or why should you not, imply a term into the arbitration agreement that gives it that effect? I also appreciate that this may be sort of the validation principle, the validation approach by the back door, but I personally cannot see the Supreme Court applying or finding that there's a principle, a validation principle, and a validation approach. I think I'm not sure that the Supreme Court has that on its radar. I think it's much more likely that the court can resort or will resort to process of interpretation and implication of terms, which are of course separate processes, but may well lead to the same result. And one can see in Sud America in particular that the court approached the case almost on a validation basis, but without saying so. And it may be that the best way to deal with the controversies and the difficulties, and rather than getting bogged down in the closest and most real connection test, which could mean anything, because after all in Sud America, Brazilian law, Portuguese language, everything was Brazilian, but it was English law because that was the law of the seat, and that somehow shifted the presumption. I mean, that is a very unclear way of going about it, and I don't think actually there's a justification for a conflict of laws approach at all. I can't see why you would need to resort to conflict of laws principles when you have the implication of terms, and I think that the Supreme Court could take that approach. It's one of the unlikely options, perhaps, but I'll now pass over to Ben.
Thank you, Niraj. I don't have very much more to add to the crystal ball analyses that my fellow panelists have given you as to what the Supreme Court might say. I just wanted to say something briefly about stage 1 of the 3-stage analysis that we've been looking at. And that is the search for an express choice of law in the main contract that covers the arbitration clause as well. That stage is not controversial in and of itself, but there can be a range of opinions as to the extent of the effort that one should undertake to find an express choice of law in the arbitration agreement deriving from provisions of the main agreement. And the speakers today have touched on some of those differences of emphasis. I specifically wanted to give a little bit of an endorsement, a soft endorsement, to what I referred to earlier as the permissive or expansive approach to finding an express choice of law clause in the main contract, much as the court did in the Kebabji case. I do acknowledge that even in that approach, there is a tension when seeking to give effect to an arbitration agreement between two intentions that may reasonably be ascribed to the parties. The first is that reasonable commercial parties without specialised arbitration law knowledge intend all provisions of a contract, including the arbitration clause, to be governed by the one and the same system of law. The second on which we've touched a little bit more, is that reasonable commercial parties who include an arbitration agreement in their contract must have intended for that agreement to be valid and effective. Personally, I rather doubt the strength of the contention that reasonable commercial parties should be understood as having intended that when selecting a seat for their arbitration, that they intended that questions concerning the interpretation and application of their agreement to arbitrate would be determined by the law of the place of the seat. I'm not a commercial man, I'm a lawyer, but I would ascribe to the reasonable commercial person the intention of selecting a neutral venue as a seat because it is impartial, because it is easy to access, and all the other reasons that we know. I would not ascribe to the reasonable commercial person an intention that disputes as to the effectiveness or validity of an arbitration agreement are to be determined by the law of that neutral place. That said, I am speculating as to the intentions of the reasonable commercial person, and it may be that some form of empirical research could assist the analysis. Why I think it's important to prioritise the search for an express choice of law is that ultimately it is by far the simplest approach to determining the proper law of an arbitration agreement. It is essentially an uncontroversial conclusion that if there is an express choice of law, then that law will be applied when it comes to determining disputes under the arbitration agreement. I do think it gives effect to what the parties intended. I suspect that it makes it easiest of all the options for a lawyer to advise his or her client. And I also think it acknowledges what I believe are the true limits on the principle of separability and doesn't give that doctrine more weight than it ought to carry. But as with all approaches, there are, of course, limits. What if there is no express choice of law in the main contract? And what if application of an express choice of law in the main contract leaves the arbitration agreement invalid or ineffective? These are not straightforward questions, but they're nothing beyond the scope of normal processes of contractual construction. Indeed, there will always be, as I said before, scope for reasonable minds to disagree as to questions of construction of commercial contracts, but I don't see anything untoward in that, and I certainly don't see any threat to international arbitration by the fact that questions of construction arise and have to be determined. Now that essentially brings us to the end of our formal comments. We are slightly over time, but we are open to any questions from those participating in the seminar with us. We have received a number which we've tried to answer as we've been going through. And at present, I don't see any outstanding questions, but if anyone does have a question they would like the tribunal to consider, please do write it, please do present it. If there are any, while we're waiting for any questions, if any of the members of the panel do have any further comments, particularly Stephen, who we've all followed in our normative comments, you may wish to come back on some of our points, or not.
Well, the only thing I'll say is that what I sense in everyone's view, while taking slightly different approaches, that there is no major disagreement that ultimately what we should be doing is to try and validate the arbitration agreement as much as we can. And therefore, I come back to my point that if that is the aim that we are ultimately that we should protect, then we should be transparent and clear about it. and openly say that what we are trying to do is to validate the arbitration agreement, and therefore adopt a principle that allows that, whether you call it the validation principle or some other principle, that is ultimately what we're doing. And I would add again, it's entirely consistent with the policy of the New York Convention, with the model law, which is ultimately to increase recognition and enforcement of arbitration agreements and arbitration awards. I think Philippe had a comment, it seemed.
Yes, I mean, it's related to that. So I fully agree that that should be the aim. But the question for me with any approach that doesn't have a clear presumption is, what then are the touchstones, or what would you expect to be? I appreciate you would probably say you wouldn't want to commit to any particular one, but should there be a limit on relevant factors which then guide you through identifying the correct law if you start from the premise of validation?
Well, I think I come back to sort of my primary view on this, which is that the law of the arbitration agreement is really only really important where there is a possibility that the arbitration agreement is invalid, in which case the arbitration agreement cannot be enforced, or for example, in Sul America case, where even if it's not invalid, there were some limitations to how the arbitration agreement would operate. And if it's in those, and it'll be rare, I think, in those situations that it does happen. It's not something that would happen in every case, because most laws that deal with arbitration agreements, if they are in consonance with the New York Convention and with the model law, would be very permissive about the validity of arbitration agreements. So it's in those unusual circumstances. For example, in Sul America, it's because under Brazilian law, the insurer had consent was required before he could arbitrate. So that is an unusual situation. And it's only in those unusual situations that this becomes important. And therefore, I don't think that you really need that many guiding principles as to how to determine the proper law of the arbitration agreement. And aside from what is already stated in Article 2 of the New York Convention, which is that it is now void, inoperative, or invalid, and also bearing in mind what the New York Convention says, or the policy behind it, which is that when you're looking at null, void, and inoperative, or incapable of being performed, it must be by reference to generally accepted exceptions of contract law and not by some idiosyncratic rule of some national law. And if that's the situation, then I don't think you need that many principles. And if it comes to the question of just interpretation of an arbitration clause without the question of invalidity being an issue, then again, I find that it may not make so much of a difference, what actually is the proper law, because in most cases, most laws, you would arrive at a similar situation. As an example, sitting as an arbitrator, I had to deal with a similar issue where I was asked to decide whether the proper law was Singapore law or Indian law. And the only issue then was the interpretation of the arbitration agreement and not its invalidity. And I asked the parties, is there a difference between Indian law and Singapore law as to the interpretation? And they said no. And then I decided I wouldn't decide the proper law of the arbitration agreement. I would just interpret it according to principles common to Singapore law and Indian law, because I was concerned that making a decision at that stage, might bind me to a law, and then I didn't want to find that later on I found that that decision created issues with the validity of the arbitration agreement later on.
We have received a good question, which I might pose. If the main contract is not signed or executed, how can an arbitration proceeding be commenced under that contract? If it is part of the contract, on what grounds do we use to determine whether the arbitration agreement is applicable to deal with the matter of the existence of a main contract? And I might add to that, in the circumstances identified in that question, how does one approach the question of the proper law of the arbitration agreement if there is doubt as to the validity of the contract itself? Niraj?
Thanks, Ben. Yes, my view is that it will depend on the jurisdiction. In England, we know that an arbitration agreement must be in writing to be effective, and that is also a requirement of the New York Convention when it comes to recognition enforcement. But the requirement for writing is interpreted in different ways depending on the jurisdiction. There's no requirement here for signed writing. There are cases I'm aware of, I don't have them at my fingertips, but where an agreement, a main agreement, has not been signed or executed, but the arbitration agreement within it, the arbitration clause within it, has been held to be effective. I believe that was determined by going through various iterations of the draft agreement and showing that actually the parties had intended arbitration, even though they didn't get round, or they might have forgotten, or they may have omitted to sign or execute the main contract. I think the second part of your question, Ben, or the second aspect of that question, is harder to determine. How do you find a law of the arbitration agreement? How do you impute an intention or imply an intention when the parties never got round to executing the main contract? It's a conundrum that maybe one we can't answer.
The answer to that, and my colleagues will correct me, is probably that, at least as an English court or an English tribunal, would determine the putative proper law. What would be the proper law if the contract had actually been executed, and then they would ask the questions that need to be asked by reference to that putative proper law. So it is in some ways assumed, but the reality is there's no other way for a court or tribunal to decide questions that may depend on the proper law without choosing some law by which to answer those questions.
Actually, that situation, Ben, was actually, to some extent, quite close to the facts in the case of BCY and BCZ.
Indeed.
Because in the case of BCY and BCZ, involved a contract that was never executed between the parties, which contained an arbitration agreement. And at the point at which it went to the court was that was a situation where the tribunal actually had been constituted and dealt with the question of jurisdiction. And that was how it ended up before the court. So what you can take away from that is that there is, that's the operation of the separability principle in action. That even if the contract was not executed, there was an arbitration agreement that was contained in there. And the arbitration agreement was then treated as separable from the contract for the purposes of whether a tribunal could be appointed to determine whether or not the contract had been concluded and a claim could have been brought under it. And then it went to the court, and the court recognized it didn't really have to decide the proper law issue, because the two proper laws were either Singapore law or New York law. And the court in that case decided that there was really no difference in how New York law or Singapore law would deal with the issue before the court as to the validity of the arbitration agreement, whether in fact there had been a concluded arbitration agreement. But the court went ahead and dealt with it anyway, and it dealt with it on the basis of what the parties' assertion had been, because there was a fairly well-drafted arbitration clause, which had been circulated, and the parties have said, this is the arbitration clause, and we're happy to sign the agreement on this basis. And that was the basis on which the court went through the Sul America test to decide whether or not, it was the law governing the contract or the law of the sea that applied. So it's a very unusual fact situation, but it has been dealt with, and you can see it had been possible for it to be dealt with.
There's one final question. I think we have time for this, and I might direct this to Philippe. And the question is this: is there room for a standardised set of rules for determining the validity of an arbitration agreement? Something perhaps akin to the IBA rules on the taking of evidence, or the IBA rules on conflicts, and so on. Is there room for a standardised set of rules?
I think there might be, but you might then run into the difficulty of how different planes of sort of English domestic law with the Arbitration Act structure, the New York Convention, and then institutional rules that are specifically chosen by the parties interact. And in a sense, unless there was an express choice in favor of such a standardized international set of rules, which in a sense, if parties are that sophisticated, you would expect them to cut to the chase and just specify the proper law of the arbitration agreement. But it would be an interesting thing to consider, but I think that's the main limitation to that sort of approach, because how would it come in appropriately as something that determines the proper law of the arbitration, at least from an English contract perspective?
I think, unfortunately, we have to draw proceedings to a close shortly. I just want to finish with one final, very short substantive point, which picks up a number of the questions that we received during the seminar. And the short point is, yes, if you include an express provision specifying the proper law of the arbitration agreement in your arbitration agreement, you can forget everything we've discussed today. We are only dealing with a situation where people have not done that. And indeed, I think in all our practices, we are now typically advising our clients, if we get the opportunity to do so, to include an express choice of law provision in their arbitration agreements. With that final word, I do want to say thank you to everyone who joined us this afternoon, this morning, both old friends and new friends. And thank you also to Stephen, Philippe and Niraj for sharing this seminar with me. We would be very keen to continue the discussion with you. So please feel free to drop any of us a line at any time. We were asked in one of the questions if we could provide a list of the authorities we've mentioned in this seminar, and we will of course do that, and we will make that available. And the final point is this: we are proposing to hold another webinar once the Supreme Court has issued its decision on Anchor and possibly Cabib G. We expect that to be towards the end of this year, from October onwards. So please look out for that. So thank you all once again. Good afternoon, good morning, and good day.
Good morning.